We start. Welcome everybody and a special welcome to all the participants. First, let me point out that this is the first of the series of webinars that is being conducted by the Arbitration Committee of IMC on the topic of evidence in arbitration. There are going to be further webinars on this very topic with other speakers also. So we get different perspectives and more on the burning issue of evidence in arbitration, which vexes many as to what kind of evidence has to be laid and what is the level of evidence expected in arbitrations. So today is the first of the series, and as I call my good friend Ketan Parekh, an opening batsman on this series on evidence in arbitration, let me begin by a small anecdote, and I can see Ketan already smiling. Many decades back, both of us were briefed in a matter where it was a trial, and Ketan was leading me. I must say it was a very eventful trial and a learning experience, with both of us complementing each other, me in a small way, and Ketan at his very best in conducting evidence, which included examination in chief and cross-examination. Those were not the days of affidavits of evidence. So the evidence had to be led orally and cross-examination conducted. It was such an experience in the High Court that having a trial going on there on virtually a day-to-day basis was a learning experience. So I've never seen Ketan, lose his cool or get excited. But that was one matter where I heard a lot of expressive words from him while the trial was on. So with that, let me introduce Ketan. Ketan is a senior counsel practicing exclusively now as counsel in arbitration matters. He used to act as an arbitrator, but for good reason or otherwise, he has stopped acting as an arbitrator. Ketan has got a double master's in law from both Oxford and Harvard universities. He was a part-time lecturer in the Government Law College at Bombay. He takes a keen interest in the spread of practice of arbitration and in dissemination of knowledge on arbitration. He was amongst us as an active member of IMC's arbitration committee for several years. In fact, Ketan had a very big role to play in the devising of the 7-day arbitration course, which is conducted annually by IMC and its arbitration committee. Fortunately, till today, he continues to find time to remain as one of the main speakers in the committee's flagship program, the 7-day course on arbitration, which is being conducted continuously without a break for the past 18 years. Ketan will be taking us on various aspects of arbitration in evidence, which many say, and I concur, is his forte. The moderator for this session, this webinar, is Ms. Sneha Fene, who's also a committee member. She is an advocate and solicitor with 19 years of experience. Of these, 16 years are as an independent counsel. She's an alumna of the Mumbai University, where she was the university topper in the 5-year law course. She also topped the solicitor's exam in Mumbai conducted by the Bombay Incorporated Law Society. She has handled a variety of civil and commercial matters in several forums, including Bombay High Court, City Civil Court, NCLT, Supreme Court, and also in arbitration proceedings. She has also received appointments as arbitrator and as a mediator from the Bombay High Court. As I mentioned earlier, she is a member and a very active member of our arbitration committee. She has one more feather in her cap, that she is a certified advocacy trainer by International Advocacy Training Council, IATC, a global organization specializing in advocacy training, which works through bar associations or councils around the world. And to add, let me just recently, Sneha was in Malaysia, and she and another fellow trainer were very well recognized and applauded for their skills in advocacy training. Congratulations, Neha.
Thank you.
On this. And now I must also introduce some of our committee members, the usual suspects who are present today. My co-chair Bhavesh Panjwani, Shikil Suri, who heads our webinar committee, the IMC Secretariat consisting of Sia Wagle and Prajakta Paladwar, in case I forget to mention them, and anybody else. Any other of our committee members there today? I don't think so, but that's the speciality of my committee, that they do a job and then they vanish, but they do the job. So over to you, Sneha. Take over.
Thank you, Gautam bhai. Before we begin, I just want to let the participants know about the format of the course. So Mr. Parikh will be addressing us on the topic. While his address is on, I would like the participants to put in their questions in the chat box so that those questions can be shortlisted. And after the talk is over, we will shortlist a few questions and put them to Mr. Parikh. With that, without much ado, may I request Mr. Parikh to address the participants.
Good evening, and thank you very much, Gautam, for your very kind words. You being a friend, you're always showering more praise than I deserve. Well, anyway, the topic that I will address this evening is about how to draft an affidavit of examination in chief. And what I'm going to talk about is possibly elementary for those who have been in the practice for a reasonable amount of time. It's probably meant for juniors and those who are starting in their practice. So in that sense, it is somewhat elementary. But having said that, if you have practiced in court or in arbitration and seen affidavits of examination in chief, you will agree with me that most of these affidavits leave a lot to be desired. And therefore, probably what I say may make a difference to many of us. With that, let me start by first talking about how things were before the examination in chief by way of affidavit came to be permitted. And as you would have heard, examination in chief was an oral exercise. You had to put your witness in the box and ask him questions. And what he said was recorded as his examination in chief. And those who have done it will agree that it was quite an art. Cross-examination might be easier. Examination in chief was more difficult because to get the witness to say what you want him to say so that you can prove your case was not always easy. Even if you had told him in advance that this is what is expected, the words do not exactly come out from his mouth as you would like. So it was quite an art to get out of your witness's mouth the answers that you want, particularly because, and this was the main hurdle, no leading questions were allowed in examination in chief. Why I am saying this and why I am emphasizing this is that when we come to the affidavit that we filed today, you will realize that the entire concept of examination in chief and no leading question has gone for a toss because the expediency has taken the place of what is right. Leading questions at that time were not permitted for 2 or 3 good reasons. One was that the advocate should not prompt his own witness about what he should speak. Because otherwise it's very easy for me to ask questions and witness only keeps saying yes. You were there at this side, he says yes. You did this, he says yes. And somebody said this and he says yes. He only says yes and you get your story out. So that's not how evidence should go. Secondly, the party who calls the witness normally knows what the witness is going to say. That is why he calls them. And therefore, if leading questions are allowed, the questions will be so framed that you get only the positive parts of the facts out of the witness and leaving out the negative parts. But if leading questions are not allowed and witness is allowed to say what exactly happened, you can't filter out things which are not favorable to you. And thirdly, because ultimately the court wants to know what the facts were as the witness noticed them and not what the advocate would like the what version the advocate would like to be recorded in evidence. So for all these reasons, leading questions were not permitted. Now, both in court as well as in arbitration, oral evidence or oral examination in chief is completely done away with. So basically, it is the advocate who prepares the affidavit. Therefore, this whole concept of no leading questions, let the witness talk, let the facts come out from witness's mouth, has gone completely for a toss, because now the advocate actually writes the evidence. Witness only checks, of course, that it is correct, but it is the version which advocate would like the to come on record, and witness signs at the foot of the affidavit. But be that as it may, this is what the facts are today. And so we will now deal with how do we go about doing this task. First question is, how do you select the witness for proving your case? Is there any qualification for a person to be a witness? If you look at the Evidence Act, old Act section 118 and the new Act section 124, it does not set out any qualifications for a witness. All persons, it says all persons shall be competent to testify. The only restrictions are if the person is a minor or of 10, not even minor, but of tender years, and he doesn't know what he's talking about, or a very old or ill person who doesn't know what he's talking about. These are the persons who may have some limitations, and therefore may not be qualified as a witness. But otherwise, anybody who has knowledge of the facts which are relevant to the matter can come as a witness without any restriction. Now, there are two things which we often come across. Whenever there is a company which is a party to the proceeding, most of the times we find that when the witness is examined on behalf of a company who is a party, the witness produces a board resolution or a power of attorney, whereby the company authorizes the witness to come forward as a witness and give evidence on behalf of the company. This is more or less universally done, but it is not required at all, because you don't need an authority from the party to come as a witness. The party calls you as a witness, and you can, of course, appear as a witness and give your evidence. No board resolution or no power of attorney is necessary for that purpose. The second scenario which often happens is that the individual who is a party to the proceeding has given a power of attorney to some other persons, and the constituted attorney comes forward as a witness. Now, if the constituted attorney was personally involved in the facts of the case and has personal knowledge of the facts of the case, no doubt he is qualified and entitled to come forward as a witness and give evidence. And he doesn't even need the power of attorney for that purpose. But if he does not know the facts of the case personally, it is then the power of attorney does not entitle him to come and depose about things which he does not know about. So again, power of attorney is irrelevant. He can only come as a witness if he has personal knowledge of the facts of the case. So these are the two things which we often come across, and one must keep in mind. What are the restrictions or limitations on a person deposing? As I already mentioned, the main and the most important limitation is that any person who comes forward can only talk about what he has personal knowledge of. And personal knowledge, of course, you are aware, is knowledge acquired through your own senses. I can talk about what I saw. I can talk about what I heard. I can talk about what I touched or sensed. I can talk about what I read, but I can't talk about what somebody else saw, heard, felt, or had opinion of. So it is restricted to your own personal knowledge. That again brings up the question which often arises. You so often find witnesses who come and say that I am deposing on the basis of records, or I'm deposing on the basis of books, etc. Is it permissible? Now, I'm assuming that the person who says I'm talking on the basis of records is a person who doesn't know what actually happened of his own, in the sense of, as I said, that he saw or he heard or he felt. But he's just reading a particular letter or a particular record, and by reading it, he says, oh, it is so stated here, therefore I am saying this is what happened. If that is the evidence that he leads on the basis of records, in my view, that is as bad as hearsay evidence. Hearsay evidence, again, you're aware, is evidence which is not of my personal knowledge but it is evidence of what I heard from somebody else. So somebody else, for example, attended a meeting and he knows what transpired at the meeting. He comes out of the meeting and tells me what happened at the meeting. And I come as a witness and say, this is what happened at the meeting. My statement is based purely on what I was told by that person. It is not because I attended the meeting. It amounts to hearsay evidence and it is not permissible. Equally, suppose that person doesn't tell me what happened at the meeting, but he wrote a letter to me or an email to me, and he wrote in that email or letter as to what happened at the meeting. And then I come forward as a witness and say that I am testifying on the basis of record. Record being the letter which that person wrote to me. In my view, whether he tells me orally or whether he tells me by way of a letter, my knowledge is still based on what he tells me orally or in writing. And it is equally a hearsay evidence. Therefore, strictly speaking, a person deposing on the basis of records is also only giving hearsay evidence. There is another problem about person deposing on the basis of record is, now, if I have records which I'm reading and then telling the tribunal as to what happened, what stops me from simply producing those records for the perusal of the tribunal instead of me reading it and then telling the tribunal what happened? Tribunal is equally capable of reading it. All the lawyers appearing are equally capable of reading it. Therefore, you have to, if you are deposing on the basis of records, you are not entitled to do that, but you should simply produce the records on the basis of which you are talking. And those records will speak for themselves. Those records can be read by whoever is in the matter and to find out what happened and decide whether how much of it is credible or believable. So therefore, this is about deposing on the basis of records and hearsay. Now, why is hearsay evidence not allowed? What is the objection to it? There are two fundamental problems with hearsay evidence. One is that the person who comes as a witness is not, as I said, himself not in knowledge of the facts. He says what somebody else told him. Now that somebody else who told him what happened, he's not talking on oath. A witness, as you know, will come forward and testify on the basis of oath. He's saying that he's taking an oath that whatever he will say will be the truth. But the person who is telling him as to what happened is not on oath. So that is one problem with hearsay evidence. And secondly, and most importantly, the person who is giving this information to the witness is not available for cross-examination. Now, if I ask the witness anything about in cross-examination, he will say that this is what Mr. X told me, and that is all that I know. So I mean, I am faced with a wall. There is nothing that I can ask this witness about his statement as to what somebody else told him. It is that somebody else who has to offer himself for cross-examination so that his statements can be verified or can be tested by cross-examination. And believe me, cross-examination is a very, very powerful tool to show if the testimony is false. And if the person who says the statements or speaks is not coming forward but telling it to somebody else, then the whole purpose of cross-examination is defeated, These are the reasons why hearsay evidence is not permissible. It's not a procedural issue. It is a very important natural justice issue. It is a very important substantive law issue, because if you are trying to arrive at the truth, then these statements by a person have to be tested by way of cross-examination before any credence can be given to those statements. And that can be done only if hearsay evidence is not permitted, and the person who wants to testify has to come forward as a witness and offer himself for cross-examination. Very quickly, I mean, hearsay can be a very long topic and I can go on and on. But very quickly, when we say hearsay evidence is what somebody else tells me, there is a fine distinction between what is hearsay and what is not. Because sometimes what is relevant is what did that person say, and not whether what that person said is true or not. Let me give you an example. Say I am facing a disciplinary proceeding because I slapped Mr. X. And my answer is that I slapped Mr. X because Mr. X, before I slapped him, said that my father is a liar. My father is a very reputable person, and if he says he's a liar, I get instigated to slap him. So the question is, did Mr. X say that my father is a liar? So the question is not whether my father is a liar. Question is whether X stated that my father is a liar. So anybody who heard X say that can come forward and say that yes, X said that Mr. Parikh's father is a liar, and that's evidence is permissible. It is not hearsay. Why is it not hearsay? Because what is to be proved is what did Mr. X say. So whoever heard him say that can testify of his own personal knowledge. But suppose my father was being tried for, or my father was suing for defamation, Mr. X. And the question was, Mr. X says that I was right in saying he's a liar. Then the question is my father a liar? Not what Mr. X said. Now, if that is a question, that statement by Mr. X becomes hearsay. Merely saying that, oh, X said that my father is a liar, that proves that my father is a liar, does not, one doesn't follow from the other, and therefore it becomes hearsay evidence. So hearsay evidence depends on what is the question being tried. If the question being tried is what did X say, then anybody who heard him say that can say what he said. But if the question being tried is whether what he said is true or not, then his statement becomes irrelevant. You have to prove the fact independent of his statement. Going forward, when you sit down to draft an affidavit, there are 2 or 3 things which everybody is very tempted to do and which one should avoid doing. One is, don't just convert your pleading into a first person singular statement. Instead of plaintiff says, you say I say. Instead of claimant says, you say I say, and you convert your pleading into your affidavit. Please don't do that, because that is not what the evidence is about. Your statement of claim or your pleading is to put forward your cause of action. It contains several things which need not be on evidence at all. It contains submissions. It contains terms of the contract which are relevant. It contains details which are not to the personal knowledge of the person verifying. They are on information and belief. So all these doesn't go into evidence. Therefore, please don't mechanically convert your pleading into your affidavit of evidence. Second thing, you do not need to reproduce the content of any document in your affidavit. So often we find that there are paragraphs and paragraphs devoted to reproducing so-called relevant terms of the contract in the affidavit of evidence. Now, once you produce the contract and it is marked as an exhibit, the entire contract can be read at the time of arguments. Your oral evidence doesn't have to again say that the contract contains these terms. Not necessary at all. And equally, we find that in paragraphs after paragraphs, we reproduce or we summarize the contents of correspondence. We say by letter dated XYZ, plaintiff said this. Next paragraph, by letter dated ABC, the respondent replied like this, and it goes on. You have 100 letters to exchange, 50 letters exchange, you have 50 paragraphs of your affidavit devoted to what each letter says. Not necessary at all. If the correspondence is proved either by admission of the parties, which is normal, or sometimes by proof of the witness, then the contents of the letters are on record to be read at the time of arguments. Your affidavit need not produce one word of those letters. You don't even need to depose to the letters which are already admitted and marked in evidence. Your affidavit of evidence need not even refer to it. You can simply say some correspondence are exchanged and you leave it at that. Not necessary to narrate the details of correspondence or the contents of the correspondence in your affidavit. And the third thing you must not do is to make any submissions in your affidavit of evidence. Your affidavit contains statements of facts as to what happened. Submissions are for your lawyer to make when he argues the case. They may be there in your pleadings because you have to make out a cause of action, but your affidavit of evidence need not contain any submission at all. That X committed breach, or that this amounts to a breach, etc., etc. All that is not necessary at all. So these are the three things you must avoid when you're drafting the affidavit of evidence. The most important and the most difficult question is, what do you write in your affidavit of evidence? We discussed what you should not write, but what is it that you write? It's an exercise which takes a little time, but I think it is necessary for two reasons. First, it makes your affidavit precise. And secondly, it makes sure that you don't miss out on what you need to prove. What you need to do is study the pleadings in detail and jot down all the matters or statements of facts or statements of relevant facts, not every fact, but statements of relevant facts. Relevant facts are facts which you need to prove to succeed in your case. So all statements of relevant facts which are in dispute, say you aver something, the respondent has not admitted it or has denied it, jot it down. Jot down all such relevant facts which are disputed by the other side. So that we will do, you will check the claim and the statement of defense. You will also check defense and the rejoinder. If there is a counterclaim, you will do that also. So all these pleadings you will compare to jot down all the issues of facts which arise in the matter. And don't be guided by the issues framed by the tribunal, because the tendency of tribunals is to frame as few issues as possible. And they don't really reflect the entire matter. They don't reflect all the disputes which are arising from the pleadings. So do your own exercise and find out what are the disputed facts arising out of the pleadings. That is your one set of material which you require. Second is also jot down what is it that you will need when you are arguing the matter by way of facts to support your case. Now, normally the facts which establish your right are pleaded: your contract, the performance, the breach, and the consequences. But what is normally not, at least not set out in detail in the pleadings, is the monetary quantification part of your claim. When you once you have established your breach and you have suffered a loss, in your claim you will just mention the amounts which you are claiming by way of contractual dues, by way of damages, etc., etc. But at this stage of evidence, you seriously need to sit down, take up each monetary claim and ask yourself, how am I going to prove the quantification of this amount? And you will realize that you will need probably a number of documents in order to prove the claim that you're making. For example, if you're saying that I am suing for a price of goods that I have delivered to the other side, you will need you will need the documents which will show that you supplied the goods to the other side, the invoices, your bank statement or your ledger account or both, which will show how many out of these invoices have been paid and how many remain outstanding. And these documents together will show or prove the balance amount that is outstanding. More documents may be required when you are proving damages. For example, you say that I overstayed on a construction contract and I incurred extra expenses because of the delay and my longer stay on the project. You may have to think of collecting all the documents which will prove your expenses, which will be in the nature of, say, salaries or wages to the staff, the invoices for goods supplied, if any, invoices for services supplied, if any, proof of payments of all these invoices by way of either bank statements or by way of accounting records, vouchers, and by way of ledger accounts. And all these documents will have to be proved. You will have to prove your ledger accounts through your accountant. You will have to prove your invoices to your project person. You will have to prove your bank statements, etc., etc. So therefore, second set of material you need to collect is what is it that I require for me to argue and succeed in my claim? What are the facts that I need, and list them out. These are the two sets of materials which will help you draft your affidavit of evidence. Sorry, the third thing before I forget. So these are the two things. Third thing is go through the defenses of the other side. And what are the answers that you have to give? What is your, if he says, for example, your claim is for price of goods sold and delivered, and he says, sorry, but the goods were defective. So you need to meet that defense. You need to answer that defense. Obviously, you'll have to therefore show that goods were not defective. They were of proper quality or the contractual specifications. So therefore, you will have to either show that before the supply, these are the tests that you carry out in your own factory or whatever you do to make sure that the goods are of the requisite quality, or that after having manufactured it, you had offered them for inspection and the other side inspected it and okayed them, or that they were offered for third-party inspection and the third party has given a report saying that goods are of a proper quality. So this is the kind of material you will think of, which you will require to meet the defense of defective quality. So similarly, look at the defenses, think of what answer you want to give and you will be giving, and then think of what facts you will need in order to support your answer. So these are the three sets of facts which you will need to incorporate in your affidavit. One is, again, to repeat, disputed facts arising from pleadings. Second is facts which you require in support of your case. And third, facts you require to answer the defense of the other side. And this is what your affidavit will consist of. And lastly, we all go through admission denial, and there will be documents of yours which the other side would have not admitted or denied. Your affidavit needs to prove the disputed documents. That is the fourth part of your affidavit. And I will discuss in a short while certain documents and how to prove them. So this is what you will incorporate in your affidavit of evidence. And next topic immediately is, of course, the how do you prove a document which is disputed. There are documents of various types, and each document may need slightly different evidence. If it is a contract, you need to, of course, depose that there was a contract and then prove the signatures of the signatories to the contract. So the factum of a contract and the signatures on the document is how you will prove a written contract. Correspondence, letters exchanged. Email will come to separately, but say letters exchanged between the parties. So if I have written a letter to you, obviously the original of the letter will be with you. I will have a photocopy or a carbon copy with me. So first thing, in case of letters, now it is not so much a prevalent way of corresponding. So we don't really come across a lot of letters these days. But whenever you do, and if it is in dispute, If it is a letter sent by you, it is advisable that you give a notice to produce to the other side to produce the original of the letter. Because what you have is a copy. What is strictly speaking, although Evidence Act doesn't apply, etc., but strictly speaking, the original has to be seen. So ideally, give the other side a notice to produce all those letters which you have addressed to them, so that the original are lying with them and which they are disputing. Having done that, you will have to prove the copy, because other side, if it is disputing the letter, it's going to say that I don't have any original, I have not received any. So you will have to prove the copy, you will have to prove these facts. First, on the copy, if there is a signature, you will prove the signature. Two, you will prove the delivery of the original to the other side. Either you have an acknowledgement or a rubber stamp on your copy, or if neither, then if it is a personal delivery or whatever is the normal mode of delivery, you'll have to prove that. Thirdly, you'll have to prove that the copy that you have is a true copy of the original which you delivered, which you can do by saying that it is a carbon copy or it is a photocopy done in the ordinary course of business, etc. Or the author says that I wrote the letter, I have seen the original, this is a true copy, whichever way, but you'll have to prove the copy. That is how you prove a letter. How do you prove emails, which is the most prevalent method of correspondence these days? I will only tell you what I do. I'm not saying this is the best or the only correct method of doing it. But you will depose about the email system that you have. Most of the companies will have their own server, their own web address, and their own email IDs. So you'll have to depose about that. And you'll have to depose that all the emails which come in or go out are preserved in the server and they are not amenable to alteration, etc. And then you will have to prove that a particular email was written on a particular date. You will have to say that the email IDs which appear in the email are all the correct email IDs of the addressees, and that it was sent, the copy of the email is lying in the sent folder of your record, and that the email did not bounce back from any of the email IDs that you sent it to. This is how normally you will prove the email. You will offer inspection of the soft copy of the email in your sent folder to the other side if it desires to have an inspection. There is, of course, since you'll be producing a printout of the email, Evidence Act permits that you file a certificate, 65B under the old act and 63 under the new act, which provides for the contents of the certificate. And that certificate will testify that your computer system is working well, nothing is wrong with it, etc. The details are there in the section. So you file that certificate along with the email. And this is how you can prove an outgoing email. Incoming email is a little easier because it's received by you. So you have to only show that you are the recipient and it was received in the ordinary course of business. Again, you'll offer inspection of the soft copy. So this is how emails are dealt with. If you are dealing with a certificate issued by somebody, and a statement made by somebody else, or an opinion given by somebody else, you are not qualified to talk about the truth of contents because the document contains an opinion of somebody else. And the person who holds the opinion has to come forward and offer himself for cross-examination. You can only, at the highest, only depose to the existence of an opinion. Say you approached a chartered accountant, obtained an opinion on a certain tax matter. You can say that I approached him and I received this opinion, and you can tender it as opinion received. It doesn't prove the truth of the opinion. That only the CA can come forward and depose to. Accounts. How do you prove accounts? The law gives a lot of credence to accounts maintained in the ordinary course of business. What is ordinary course of business? It means that I am not sitting down today. Today I have a dispute with you. So I sit down today, open a new uh, Excel sheet or a new book, physical book, and start writing an account for last 2 years today, and write whatever entries I want to write, and then create an account like that. That is not an account maintained in the ordinary course of business. An account in the ordinary course of business means an account which is maintained day to day. Whenever something happens, an entry is made in it as in a normal course of business. Because so therefore that is a record which is maintained, not keeping any dispute in mind, but that's the normal way the business is run, and therefore a lot of credence is given to it. Therefore, when you're proving the accounts, first thing you will prove is that what you're producing is an account which is maintained in the ordinary course of business, and entries were made in it real time, as and when the transactions happened, the entries were made into the accounts. Ideally, it should be deposed to by the person who maintains the accounts, the person who actually maintains the account, because that's the only person who can say that yes, what is written in this account is correct because I have written it. But you don't always find a witness who was the accountant for, say, last 5 years accounts or last 10 years accounts. Maybe you can bring in the higher officer, a chief CFO, or some other senior accounts officer who can say that all these were maintained under his supervision, and who he was checking these accounts and keeping an eye on it. And probably that may also be accepted. Normally, accounts are now maintained in the soft form. So again, you may file a 65B certificate, equivalent to now 63 certificate, to prove the soft copies. And the witness will have to depose to the correctness of the accounts. Merely tendering accounts doesn't prove the correctness. He'll have to depose to it. Yeah, this is basically the major types of documents that you have to deal with and how you will prove them. How do you prove monetary claims is the last thing I have with me. And that is, we've already discussed some of it when I talked about what should go into your affidavit. Only for the damages part, because I've already talked about what happens if we want to claim price of goods or contractual dues or claim for expenses. But in damages, very often you claim damages by way of loss of profit or loss of future income. Had the contract been performed, I would have earned so much out of this contract. Or it may be a contract which is prematurely terminated, and you would have said that had I done the full work under the contract, I would have earned so much profit in this contract. This may require evidence of an expert, because we are talking of estimating what might have happened in the future, not what has already happened. So it's not factual in that sense. It is a projection of what might have happened. And an expert, say you want to prove loss of profits in a business, you may have to examine an expert who has expert knowledge of the industry in which your business is, and he has knowledge of what kind of profit margins are there, what kind of sales forecast can be made, etc., etc. He knows the industry facts to project what kind of sales might have happened. He knows how the other entities in the field are performing. So you may need to examine such an expert who can project and depose about what, in his opinion, would be the profits that your company might have made had it continued to do business. Equally, if you want to show what profits you would have made in performing a particular contract had it been allowed to be performed to the full extent, maybe you don't need an expert, but you will need somebody who is familiar with the accounts and who can, based on that, say what costs were incurred in the past, what were the projected costs, projected income, and what would have been the profit. So this kind of evidence will be necessary when you are trying to prove damages. One head of damage or two heads of damages which are normally made, but I haven't seen them succeed, are damages for loss of reputation and damages for mental agony, harassment, etc., etc. We make these claims to maybe try in an attempt to scare the other side out, I guess. They don't they don't really there's not much basis for that. For example, mental harassment or mental sickness because of the behavior of the other side doesn't establish a claim. You have to actually show that the mental harassment resulted in some physical sickness and you incurred expenses to cure that. And now all this never happens and you would never succeed in proving it. So it's just a claim. Don't bother too much about it in your evidence. So also claim for loss of reputation in a normal contractual matter. Loss of reputation is a very remote claim. That is not something which directly arises out of the breach of contract. So these are not claims which are normally to be taken very seriously even by you yourself. So you may add a paragraph in your affidavit if you like, but I don't think there's much you can do about it, and don't expect to succeed on these claims. Yeah, basically this is my quick summary of how affidavits should be done. I have promised Sneha that I'll give her plenty of time to ask questions because she herself has some very interesting questions to ask me, and I hope, and probably you all also might have. So I'll now take your questions rather than talk. Sneha, over to you.
Thank you, sir. That was really an enlightening session, really succinct, and kind of gave us an overview of evidence in arbitration, or evidence in chief. Before I take some of the questions from the participants, maybe I can just put some questions that I have.
Sure.
Sir, you said that one of the reasons why hearsay evidence is not permitted is that the person who has personal knowledge is not on oath. So therefore, sir, even in arbitration proceedings, the person must be given oath, isn't it? So
yes, I believe so, because ultimately, what is evidence?
Correct.
Anybody can say what he likes, I mean, you give credence to evidence, rightly or wrongly. I'm not saying that you take oath, you always speak truth, but at least it's an attempt to make person to speak truth by making him take oath. And the belief is that on oath, he will not lie, or at least he will be visited with some consequences if he lies on oath. So yes, evidence should be on oath and is on oath. And the indication of this, I mean, Arbitration Act doesn't have any elaborate provisions on this, but if you see section 27, it uses the word testimony. When you said you take assistance of the court to summon somebody, it uses the word testimony. Now, testimony is essentially a statement on oath. So that's an indication that evidence, and even otherwise, I mean, as a common sense, a person comes as a witness, he has to speak on oath. Otherwise, what is the difference between a witness coming and deposing and somebody else just making a statement on a letter or whatever? So yes, it has to be on oath in my view.
And sir, does there have to be a particular form of the oath which needs to be administered, or even if there is no oath formally administered, it can be considered that the person is on oath?
Well, that's for the tribunal. I would prefer that oath is actually administered, because ultimately whatever effect it has to have if you make him take the oath and not just tell him you are on oath. So yeah, and the format is universal. I don't think there is any change in the oath that you take. You either take it in the name of God or on solemn affirmation, but the oath is the same. The truth, the whole truth, and nothing but the truth.
Okay. So the Calcutta High Court in one of the cases has held that even a statement made by a counsel on instructions could be considered to be evidence in arbitration. Do you have any views on that?
Honestly, I tried. You had told me this question is coming my way. I tried to look up the judgment. I couldn't find it on SCC online, so I have not looked at it. So I don't know what the facts of that case are and what is the reason court said that. So I mean, unless one knows the facts, one can't criticize the judgment also. But if one has to take it only as at a face value and say that every statement by a counsel has to be taken as a statement on oath, it's kind of going a little far. But maybe on the facts of that case, it might have been justified. I have no idea.
Riya Sharma is asking a question. In what ways do the evidentiary standards in arbitration differ from those in traditional court proceedings under the Code of Civil Procedure?
The standard answer, yeah, the arbitration is supposed to be informal. It is supposed not to be bound down by the technicalities which bind down courts sometimes, although technicalities may have its own reason and value, but arbitration is supposed to be informal. So the particularly for the purpose of proving of documents, the standard which the courts expect is not expected in arbitration. What standard will be applied varies from tribunal to tribunal and arbitrator to arbitrator. So every time we go before a new tribunal, we are wondering what level we will have to meet unless it is specified upfront. But ideally, it should be a very, very relaxed standard because general experience shows that most of the times the documents are not really in dispute. We don't admit documents more because we say I am not aware of the documents. I'm a third party to the document, but not because I seriously suspect that the document has been fabricated. That fabrication happens very, very rarely. So therefore, I think easy standards for accepting documents should be the norm, and many tribunals do that. Others need to do that, I feel. Yeah. As far as the ultimate test of whether certain fact is proved or not, I think the same standards apply. When the tribunal or the court is sitting down to decide the matter and trying to decide whether certain fact is proved or not, it will assess the evidence in the same manner as the other will. There is no difference there. Yeah.
Okay. So it is often said that the first principles of justice must apply in even arbitration proceedings. Could you give us examples of what is meant by the first principles of justice, apart from the fact that both parties have to be heard, they have to be treated equally and fairly? Apart from that, is there anything else which must be kept in mind?
So I looked up again. Thanks for giving me a heads up on what you're going to ask me. So I looked up what is first principles of justice, and repeatedly the judgments go back to one judgment of an English court in the matter of Harvey versus Shelton, decided in 1844. That is where I think most of the judgments refer to first principles of justice as mentioned in that judgment. And the few examples which I could gather from the judgments of what are first principles, not that this is exhaustive. One is not receiving information from one party without disclosing it to the other. So it should be disclosed, not behind the back of the other. Then both sides must be heard, each in the presence of the other. An opportunity of being heard has to be granted. The tribunal must consider the arguments of both sides. You must not permit one side to use means of influencing the conduct and decision of the tribunal, which means are not known to the other side. And hearings have to be in the presence of all arbitrators and parties. But these are just examples. Basically, first principles of justice is basically whatever is fundamental to law, whatever there can't be an exhaustive list of what all these principles are. So just all fundamental principles which we have always follow when undergoing hearings are the fundamental principles which even the tribunal will take into account and follow.
Yes. So especially in view of the fact that a lot of arbitrators may not necessarily be lawyers or may not be judges or retired judges, could it be said that what has to be kept in mind by them is that there has to be fairness, or both parties have to be treated fairly? So whatever they do has to be done keeping that in mind. Would that be a good?
Yes, I guess so. If it has to be put so simply as to be understandable to a non-lawyer, yes, be fair to both sides, and no party should be prejudiced by what you're doing. Is a fair way of putting it. Yes.
So as far as the Section 65B certificate is concerned, suppose the witness who is giving evidence does not produce the certificate, but he gets it from someone else. So is the other side entitled to cross-examine that person who's given the certificate, or can the documents be said to be proved on the basis of the certificate?
I don't find any provision for cross-examination of the person who gives certificate. And normally I have not seen anybody asking for and cross-examining a person, but I would assume that if in a given case I have a serious case of saying that the certificate is false and I can prove it, and I want to examine the person giving certificate, I guess the tribunal will consider it. Because ultimately, as you say, first principles of justice, if something is being used against me, I must get a chance to test it. We don't normally ask for it because we really don't have, most of the times you don't even have disputes about the emails or the accounts, or at least we don't have any material to show that their system is defective, which has produced some defective documents or data. So this doesn't happen normally, but in a given case, if it happens, I'm sure you can apply and request for a right to cross-examine.
So as far as bank statements are concerned, would under the CPC or and court proceedings, we would require a Banker's Books Evidence Act certificate. Would that also be required in arbitration proceedings?
Ideally, no, because 99% of the times, what Bankers Books Evidence Act was passed at a time when there were no soft copies of the documents. So if you had to prove the bank account, you had to call for the records of the bank. You had to call upon the bank to produce its books of accounts in court. Now, the bank's functioning will stop if it has to keep producing its books in the court of law. It will need its books for its day-to-day operations, and therefore the Bankers Books Evidence Act, the bank will issue a certified copy of the account, and that will be treated as if it is the original books of accounts. Now, in the present day and time, A, there are no original books of accounts even with the banks, it's all soft copies. B, what is produced almost always is not what the bank, not from the bank's records, but the bank statement which you receive or which you download from the website. So you are really not even approaching the bank for producing the bank statement. So why would bank be required to give a banker's book certificate? Banker's book certificate was a substitute for banker's books. You're not calling for, you're not producing banker's books. You're not, therefore you don't need banker's book certificate. You're producing a bank statement which you receive every month in your email, right? Or you receive another email from bank specifically asking for it. So I don't think it is required. But again, tribunal to tribunal, the norms change. Some tribunal may insist on it. So I mean, should not be, but whether it is required depends on the tribunal.
So maybe even a 65B certificate would be enough then for proving also bank statements which are received by email.
Yes, but even 65B, if you ask me for bank certificate, what 65 will you give? Because you are not producing the bank statement from your own computer. It is a statement produced by the computer or the server of the bank. It is emailed to you. You can only say that my email system is faithful, but that doesn't prove that bank statement is correct by itself. So really speaking, 65B certificate also has a limitation. But yes, you can produce it because it's a soft copy for whatever it is worth.
Just to prove the existence. The truth of the contents then will have to be proved separately.
Yes, yes.
Mr. Sharad Abhyankar has a question. Are there penal consequences for filing false affidavits in arbitration?
I have to study this because I'm not sure whether the penal consequences follow or not. Honestly, I've never checked this up. So Sharad, thanks. Good question, but no, I don't have a ready answer for that.
Someone, I'm not sure what the name is asking, in addition to evidence by the parties in arbitration, the expert's opinion, including representation before the tribunal, has an added weight, assuming the sectoral experience of the expert to which the dispute pertains. What is the view of Mr. Parikh on adducing expert opinion to strengthen the matter? This is Mr. Prasenjit Guha.
Can you read the first part of the question again?
In addition to evidence by the parties in arbitration, the expert's opinion, including representation before the tribunal, has an added weight.
Okay. So, expert evidence, wherever required, is definitely useful and carries weight. one situation I already discussed, when you're proving damages, particularly future projections, loss of profit, etc., you may need an expert. And it is only an expert who can depose about it. The other aspect where technical experts' evidence may be necessary is when the matter has technical aspects. For example, mecha- a matter relating to supply of machinery or similar equipment which are alleged to be defective, and all the technical aspects of the machinery has to be gone into. Sometimes there are software disputes and defects in the software, etc. Now, these are matters which a normal layman, a judge, or even a lawyer may not be completely familiar with, and they need assistance from an expert. Even accounting, sometimes there are accounts, and so say share valuation is something which it's an expert area. There are methods of valuation, there are factors to be considered. So these are matters where assistance of an expert is not only useful, but it may be mandatory, necessary for you to prove your case. You can't yourself prove these things most of the times. So yes, but if there is any follow-up, because I'm not sure whether I answered the question fully.
Mr. Guha, maybe you can unmute Mr. Guha if there is any. His name is PG141, his username. Okay, maybe if there is a follow-up question, Mr. Guha.
No, sir, I'm sorry, I was unable to unmute. It's fine, sir. I mean, your
Okay.
explanation is well taken, sir.
Okay,
And
thank you.
thanks for your.
Sure.
So while we are on expert evidence, the next question would be, are arbitrators permitted to take the opinion of experts on their own without either of the parties producing an expert?
Yes, of course. There is a provision in the Act.
And if so, then are the parties entitled to cross-examine, or would it be called cross-examination, or would it be just called putting questions? Because it's not really.
Call it what you like. I can question him whether you call it cross-examination or not. If I'm questioning him, I'm surely not asking him pleasantries. It will be to contest what he has opined about. So yes, by whatever name called, I have a right to question him. I will call it cross-examination.
Can I put a question to Ketan?
Yes, Gautam.
Ketan, Section 1 of the Evidence Act speaks very specifically that the Evidence Act will not apply to arbitration proceedings. Proceedings before arbitrators, that's the term used. And I generally find, I mean, and many others would tend to concur, that as a default mechanism, the arbitrators tend to use the Evidence Act, rely on the Evidence Act and CPC in conduct of arbitration. When even Halsbury says, I think Denning was quoted in Halsbury saying that the arbitration has to proceed mainly on principles, as Sneha mentioned, fairness and equality, and on natural justice. What is your view on this tendency to use evidence and CPC as a default mechanism in arbitrations?
See, so long as one is not applying the technicalities of both these statutes, it is okay, because I'll tell you, both are such detailed statutes that if you ignore them, and because the Arbitration Act says that they don't bind the arbitration or arbitrators. But in the absence of those statutes, and in the and no arbitrator or no parties are going to be able to agree to a whole set of rules to substitute the entire CPC and Evidence Act. You can have a few things, but not everything. Therefore, what is it that you're guided by? If you are faced with a situation where you need guidance as to how to proceed further, what is it that you look at? And these are all well-tested, long-running statutes. You certainly avoid technicalities, but surely, I mean, I guess deriving guidance from them, I think it's fine. I mean, I am only worried that people go overboard in applying it, and they apply it 100%. And my particular grievance is about insisting on proving of documents in the method in which they are done in the court of law, which takes a long time and it is a waste. So that sort of thing is definitely to be avoided, but otherwise you can definitely look to these statutes for guidance.
Thank you, Ketan.
So, for example, one of the principles in the CPC is under Order 18, Rule 3A, that if a party is leading evidence, then he must lead evidence first before the evidence of other witnesses must be led. So, should this also generally be followed in arbitration?
So the answer is yes, because you look at the reason. This is not a procedural rule just to decide the order in which witnesses will be examined. There is a reason behind this. If I am a party, I am the main storyteller because I'm going to tell my whole story from beginning to end. But instead of me coming upfront and telling the whole story, I first put my bits and pieces witnesses in. I see where they crack and where they hold up. And then looking at what emerges out of their cross-examination, I stitch together a story which may be different from what I would have deposed to had I gone in first. Now that is not permissible. I can't be allowed to make up a story after looking at how my other evidence has gone. That is the reason why the courts, the act says that you must go in first, put forward your full story, and then it will be tested by the cross-examination of other witnesses. You don't get a chance to change your story. That is the reason, and that reason is a good reason for arbitration also.
So then ideally, an arbitrator should make this known to the parties before evidence is starting, correct?
Yes, yes. I mean, you can't make it such a hard and fast rule that suppose somebody by mistake comes second and you say that now I'm discarding your entire evidence and dismissing your claim. It's not, you don't have to be that harsh, but you should insist on this procedure so that there is more fairness in the manner in which evidence goes. Yeah.
And a lot of arbitral tribunals nowadays ask for evidence affidavits to be filed simultaneously. Either they ask both sides to file all affidavits together, or they ask for the claimant to file all affidavits, then cross-examination of the claimant's witnesses, and then the respondent's affidavits. So would you consider this to be in consonance with the principles of the CPC or the Evidence Act, which need to be kind of followed in arbitration also?
Yeah, I guess so. I don't see any. See, the whole purpose of this is not a few tribunals. This is more or less a universal rule, simultaneous filing of affidavits. Some tribunals follow a different procedure, but most of them follow simultaneous filing. And the reason is simple: to expedite the proceeding. If all evidence is in, then you can have entire cross-examination in one session and be done with it. If Indian tribunals don't really finish it in one session, but ideally they should. And then you have an argument session and matter is completed. If you have this stage-wise thing, then the matter can stretch by another few months because of that. So there is a good reason for simultaneous filing. Or the only thing I feel one should keep in mind, which many tribunals do, but some don't, is that after simultaneous filing, there should be an inning. Both sides should have a right to file supplementary evidence to deal with the evidence filed by the other side. Because normally, as you say, claimant files, normal court proceeding or a trial, claimant goes in first, cross-examined, and thereafter respondent comes in. He has seen the evidence of the other side and he can comment on it. And claimant gets a right of rebuttal at the end on issues where burden is on the other side. Simultaneous filing, you don't see the evidence of the other side at all. And you are entitled to deal with that. There is no kind of surprise element. I often hear people say that, oh, but if he sees my evidence, he gets an advantage. There is no advantage. That's the fairness of the process. This is my evidence. Say what you want to say on it. You can't say that I will not allow you to say, and then, so therefore there should be an inning of round of supplementary filing after that. And I would even go to the extent of saying that after the cross-examination of the claimant is completed, and the respondent's turn to put in his witnesses comes, at that stage also, if the respondent feels that he needs to say something on the things which have come out in the cross-examination, he should have a right to do that. So subject to this simultaneous filing, there is no problem at all.
And if one of the parties, after filing an evidence affidavit and after cross-examination of a few witnesses, decides that it does not need to lead further evidence, can that party withdraw the evidence of the other party?
No, why not? Because evidence, affidavit of evidence comes into operation or becomes evidence in the matter only when it is tendered. It is only filed. But when the witness comes, takes oath and tenders his affidavit, it becomes his examination in chief. Till that date, it's just a document on the file. That's nothing more than that. So
It's
certainly,
completely withdrawn. So that way there is no kind of disadvantage to
yes.
Can I just, as a supplementary to this question, ask a question? That supposing the affidavit of evidence is filed, say by the respondent, and at the end of the cross, the respondent realizes the claimant has not established anything. And I don't want to file as a respondent, I don't want to lead any evidence in the matter, I'm not required to. But however, I filed an affidavit of evidence and it contains certain admissions. My withdrawing the affidavit may not help because possibly it could be argued by the claimant that there is an admission in that affidavit which is sought to be withdrawn and I can use it. Then what would be the effect of that?
That, of course. If you have admitted something, it has to be seen. You can't run away from your admission. You can choose not to lead evidence. That is your choice, and that nobody can deny you your choice. But your admissions will bind you, nevertheless.
Thank you.
We can probably take a few questions from the participants now. Mr. Rajiv Naik is asking, in the context of the answer on the party himself coming in as the first witness, how would this be resolved when companies are parties? Who would be the main witness of a company when there is more than one fact witness on behalf of the company?
The main storyteller. The party, normally the rule says party should come first. The idea is the main storyteller, the one who is going to tell the whole story, should be the first witness.
Advocate Kaustubh Zawle has a question. Any tips to prove cash transactions without receipts?
First, you have to think of the income tax consequences. No, I think cash transactions, those who undertake those know the risk that they are taking, and they will have to, I mean, you can try and prove it. It's always very difficult. It's as good as your oral contract or cash transactions. These are things which are very, very difficult to prove. You can try, but not easy, because just as there may be a genuine cash transaction and you may want to depose about it, more often than that, there will be, once you make a claim against me, I will say that I'd come to your house and given you cash. What stops me from saying that? So therefore, these are not, your statements are not going to be easily accepted unless you have some surrounding circumstances or evidence to support what you're saying. No tips on that. It's all factual. So
Sandesh Shukla is asking, could you please explain the conundrum of check and revert? What happens when the witness checks and is ready to revert with information and or document, but no follow-up questions are asked, and then later the witness is accused of suppression?
you have a choice. If my witness was asked something and my witness said, I will check and revert, and then it was not followed up, I may be able to ask him in the re-examination to answer the question. That is my choice, which I have. Witness also can, while answering some other related questions, say that I have brought this information and documents and I'm willing to answer. So that then the onus is on the other side. If he doesn't ask, then he can't be. Other than that, I mean, if this was relevant information, relevant document, and you did not prove it in your examination in chief, then you can make a lot of complaint that it did not come out in the cross examination. So, yeah.
Swanan Ganu is asking, to show payment having been made, is it sufficient to show books of accounts only kept on Tally software, or is it necessary to show bank statements?
If you have both, please produce both. If you don't, then of course make the best of what you have. If you have only the ledger account, then surely that. But if you have both, then don't keep it back. I would use whatever I have to support my case.
Karuna Matkar is asking, usually in companies or PSUs, employees who have worked on projects are no longer working with the company or PSU by the time the arbitration commences. How do we then lead the evidence in the best possible way in this situation?
Ideally, try and contact those who have left you or been transferred, etc., and bring them back. I know that is not always possible. People don't cooperate. In which case, I don't have easy answers. I mean, you have to make the most of what is available with you. It all depends on whether you have some junior person available, or whether you can produce records and prove the records which will prove your case. But it becomes difficult if you can't find if the person who actually could have deposed is not available. It's a difficult situation, and there are no easy answers, but you'll have to try and make the best of what is available to you. People do this, and although I've criticized it, you can have somebody depose from the records. Yeah.
Badlamudi Maurya is asking, in case of two different arbitrations on the same matter, where claimants are different and respondent is the same, if one arbitration award is pronounced in favor of claimant 1, then what will be the impact on the other arbitration proceedings initiated by claimant 2?
It is not res judicata. Beyond that, and there is no binding effect of an award. So I don't know. Beyond without knowing the facts, I can't tell you more than that.
I believe maybe the question is that would the evidence in one be taken as proved in the other, if there is.
If the same witness appears in the other matter, then his previous statements can be tendered. It's not as if the evidence in this matter is imported into that, but say same witness who has deposed here comes as a witness here, and you want to show him some statements made in the earlier matter, you are entitled to do that because those are previous statements by the same witness. That you can do.
Then as far as marking of documents is concerned, are arbitrators permitted to admit all documents produced by both parties without marking the same as exhibits, subject to it being decided at the final stage as to whether the said documents are proved or not, or ought to be looked at?
So you have more questions than one in that. Marking, numbering, etc. is a procedural thing. Some arbitrators give them numbers. I have known an arbitrator who said volume number, page number is the exhibit number, so he doesn't mark them, etc., etc. So that's fine. That whether you give it number, don't give it number, that's secondary. Whether you can postpone the decision as to whether the document is proved or not at the final stage. I have seen some tribunals do that. I have had debate on it with the arbitrators as to whether this is the correct method, because my only concern was that if I am told now, when I am still in the course of proving my documents, my witness is still under examination in chief, if I am told that no, this evidence does not prove your document, I have a chance to ask 5 more questions to the witness and prove the document, because I know this is what is lacking, and I do that. Or I can bring another witness if necessary and prove it. But if I am not told now that, sorry, you have not proved your document, I'm told after evidence is over, arguments have begun, I lose the chance to bring in evidence to prove a document which now I am told I have not proved. So that opportunity is lost to me. That is my grievance about postponing the decision. But I am in favor of tribunals generally accepting all documents on record, and what weight to give to the documents to be decided later. Weight, not whether it is proved. So it will look at all documents. Weight, it will decide later. And caveat is that if a party genuinely disputes a document, when I say genuinely means he's saying that I feel this is fabricated, I feel this is not genuine. Such document, the tribunal will insist on a proper proof in a formal manner. But those will be a handful, or not even a handful of documents, maybe 1 or 2 documents. Rest of the documents can be simply accepted and its weight can be decided. That will be the fastest way to deal with the documents in my mind. Some tribunals do that, but not all of them.
Gaurav Thakur asks, can an email be proved only by those who are marked on the email, or can it be proved through an IT personnel of a company who has access to server on which the emails received by officers of the company are saved?
It can be proved by the IT person also, so long as he proves the system, the faithfulness of the system, and that whatever is lying in the system is actually what is sent or received. He can prove it, but he may not be the person who can say that what is stated in the email is correct. But sending, receiving, he may be able to prove. Yeah.
I think we've covered all the questions.
Okay.
Yes,
There is a question by Prasanjit Goa, a generic question. While enforcing a foreign arbitral award by Indian court, are courts entitled to look into evidences cited in the award? So he wants your specific view. None of our view will work with him.
This is beyond my jurisdiction, isn't it? Beyond the scope of reference. I'm not dealing with foreign awards, Gautam, so I would rather skip this. So
I think can we just request Ketan to just say something that what he would advise people in arbitration, either as arbitrator, counsel, as parties, that apart from what he has already said, one or two important things that he considers in evidence that they should ensure and follow.
make it short.
Fair enough.
That is my, because
make-
my biggest grievance about the way we proceed with matters is that the evidence just does not end. It just does not end. Affidavits are running into 70, 80, 100 pages. Cross-examination goes on for days and days. That's not how it has to be done. Make it short.
Excellent. Any other tip?
Pleadings, affidavit, and cross-examination. Also arguments should be short, I think. Yeah.
Excellent. Yes, Bhavesh, over to you. Any other questions here anybody has?
no, I don't think so. I think
Okay.
last 1.5 hours we've covered quite a few.
Yes.
Yeah, and I'm sure the participants have got a lot of food for thought. So thank you, sir.
Yeah.
My pleasure.
So,
Thank you for inviting me.
Ketan, you
Mr.
always
Parekh, as is our duty and as it's a pleasure every time. Thank you very much. Because not only have you covered a lot of the topics which, were within your scope, but you've given us so many tips that, I think it was such a learning experience to attend this. So thank you very much for that. On behalf of the IMC Arbitration Committee, on behalf of all of committee members who are present, thank you once again. And thank you participants for attending and raising such questions which made us think and made Mr. Parekh also think. So thank you for that. And thank you, of course, last but not the least, the IMC Secretariat and the IMC IT team. Thank you very much.
And Bhavesh just announced now we are having a next, we will be having our next webinars on
Yes.
evidence. Just
Yes,
once
so
again.
as Mr. Mehta, the chairman of the committee, said, this is the first of a series of webinars on evidence and arbitration. And very soon we'll be having more webinars. I don't think we've confirmed a date yet, but you please keep following the IMC website. Please keep following with the IMC Secretariat. The contact details are already on the flyer, which enabled you to register. And it should not be very long. I think it should be in a couple of weeks or 3 weeks or something like that. So please do attend, and thank you for all the participants for registering and attending. Thank you very much.
Thank you, Ketan. Thank you so much.
Thank you. Thank you very much.
And before I forget, thank you, Sneha, very much, because
Yes.
the questions you have raised, that really started Mr. Parekh, I can see, started in thinking. So thank you for that.
I'm more worried of the day that I am in the witness box and she's asking me questions and cross-examination.
No, the only advantage is that questions are given to you in advance. So not only did she make me think, she made me research also. So
Excellent.
So Sneha, thank you very much for that. Okay, so I think we can now close the seminar. Unless
Yeah.
there's